Maybe we should start the Goldilocks compliance program.
This one is just right.
You're listening to the Help Me with HIPAA podcast, where HIPAA and humor collide to make learning fun. Your delightful hosts are Donna Grindle and David Sims. Relax, HIPAA help is on the way.
Hi, I'm Ginger McClush from St. Louis, Missouri, medical oncology hematology consultants, and you are listening to the Help Me with HIPAA podcast.
Thank you for that intro, and welcome to Help Me with HIPAA podcast. My name is David Sims of HIPAA for MSPs and Security First IT. And joining me is Donna Grindle of Carden. Good morning, Donna.
Good morning, David.
How you be?
I'm better, not having that allergic to Turns out one of my meds I'd been on for a while, blood pressure, suddenly bothering me. All better now. There's a little PHI to share.
Now it is UHI.
I got it. All right. So, and when this one comes out, we will have just finished the boot camp, and when it comes out, we'll also be doing an interview that we're real excited about.
Mm-hmm.
Barring any problems, we'll be interviewing Eric Decker, who's the CISO at the University of Chicago Medical, and also the co-chair of HICCUP.
There we go.
Yeah. So we're going to, in 2020, we're going to do some more to promote the use of HICCUP.
Yes, indeed.
It's called being an educator.
Yeah, but you can't. We can only do the information part. The actual implementation part, that's the listeners
and their IT team.
Don't get me on that rant.
I know, right? we did the Halloween episode. If you haven't listened to that, you'll understand. And we did vent a lot in that one. So hopefully, people start to get it, and HICCUP would be part of that to, kind of bring things along. So we're going to try to use it as a tool to educate both the businesses and their IT providers or IT department. So yay, team. Yeah. But in the meantime, I'm already, I got an email from Alex, a regular listener who cracks me up. And he sent me an email. He goes, "You're going to hate this, but when's the next boot camp?" And he goes, and then he puts like ducking from the ashtray being thrown. First of all, he said ashtray, which says, you're not a youngster.
Yeah, he's got some age on him.
Yeah. Back in the day, I used to be a regular smoker, which is something I don't recommend, anyway. But no one could tell me then because no one's the boss of me. Anyway, it's we don't know yet, but we are close to hitting a date. We are close. We are in discussions. So by hopefully the next episode, we'll know. At least. And we're only going to do 2 at the most. Yep. Period. There's 1 in the spring, 1 in the fall. That's it. Because it's just too much. All right. There's just too much. We barely can fit in a date.
I know. There's a lot of juggling. And, if we happen to do one on the West Coast, that basically means that all you East Coast people have one opportunity in 2020, and that's it.
So there you have it. But we appreciate those folks that have come to Atlanta. And in this last boot camp, we even had somebody come all the way from the West Coast in Washington. I know, right? So if you are interested in the boot camp, all the information will be on the HIPAAbootcamp.com.
All right.
Yes. Yes,
it will be.
Okay. So I think that we should at least try not to make a mess of this one and get off on one of our rants as we get started.
I don't know if that's possible.
Because This episode, I intended it to be one way, but the more I read the details, which is, again, if you just read the press release, you're missing the value.
Mm-hmm.
This is the best guidance and consulting from OCR that you can get.
Tis true.
Let's do our thing.
Okay. So do you have any other speaking engagements coming up?
Yes.
Yes.
I'm booking stuff in 2020 right now, and I don't have them written down. I'm still, it's the dates. I can't figure them all out.
Yeah.
But I'm booking conferences in 2020 right now.
Yeah,
and even have people getting me to do stuff in the fall of 2020. I'm like, wait, what? So, yeah, I got stuff, but I'll have to get it later.
Okay, cool. We do have one coming up. I mentioned, I think last week, where we are hosting an event for OCR in Charlotte. So that's going to be on Thursday, December 12th at 12 p.m. It's going to be at the Steel Creek Library. So the OCR is doing a couple sessions. One's on civil rights, and the other will be on HIPAA.
Awesome way to go, David, for making that happen.
Donna made that happen, but I'm doing the most of the work. Donna put the connections together, though.
Oh, finally, I get to tell you to do something that makes you do work.
I know. And then I have another engagement in 2020, April 29th. I'll be out in Las Vegas speaking at a conference out there. And I don't know what it's entitled yet, but I'll tell you when I have the details. But it is from the American Institute for Healthcare Compliance. I'll be speaking out there.
Yeah, because why?
Because I'm on the board of directors. What?
Go, David. Go, David.
That's right.
All right, let's get into the down and dirty, because this one, there's so much info in the civil money penalty document, the proposed determination. I couldn't even fit it into an episode anyway. So,
yeah. All right. Well, we'll do a quick break and we'll get into it. The number of medical practices that think they're HIPAA compliant is pretty staggering. Effective privacy and security are an ongoing process, not a checklist. And that's why at Cardin, they don't just assess your situation and leave you with a report, but they work with you all along the way. Call Cardin today at 678-292-5001 or visit them on the web at cardinhq.com. Aren't your patients worth it?
Are you frustrated with your current IT provider? Are you sure you're getting the security and protection you need? Are you putting your patients and your practice at risk? If you're in the Charlotte, North Carolina area, give Security First IT a call to learn more about how they can protect your patients, your practice, and your bottom line. Find them online at securityfirstit.com or call 980-288-5100.
All right, we're back. That was quick.
Yeah.
Let's roll.
All right. Okay, so if you saw the headlines.
I did.
Which many people saw the headlines. And it was all about Jackson Health System. And what do the headlines always have?
Money.
Money, honey. $2,154,000.
Mm-hmm.
Apparently, they didn't mind stroking a check for that.
This is true.
Because they didn't.
Maybe we need to start by telling people there's a difference between a penalty and a settlement.
Hit it.
Well, the biggest difference is that a settlement means they said, we don't want to pay a penalty. We want to pay less of a amount of money, but be put on the corrective action plan and all that good stuff. The penalty is when they go, I don't care. Don't want to be on a corrective action plan. Just tell me what I owe you and go away. Go away.
Yeah. I do not acknowledge, you are not the boss of me. I will stroke a check to make you go away.
Yeah. So we don't have very many of these. So what we're talking about today is not a settlement. It is a penalty.
Civil money penalty. So this is the true enforcement part. Normally we see a settlement, which is we could have been enforcing on it, but rather than that, you're going to say, my bad, help me do better.
Mm-hmm.
In these cases, they're like, yeah, we don't acknowledge that you have the authority to do this. That MD Anderson happened last year, and they're still fighting it in court.
Mm-hmm.
There's no sign of whether these folks are, because they basically said, "Yep, we got nothing else to say." When OCR said you're doing all these things wrong, they're like, "Yeah." They had literally replied, "The only thing, we've already sent you everything we have."
Mm-hmm.
So I don't know the deal. I don't know what's going on. I know there's got to be politics. But you really learn that when the press release, we know there's always the quote from the director, and it leads us to the water that OCR wants us to drink.
Absolutely, it does.
There you go. So, as is our custom,
I will play Roger.
You play Roger.
Roger.
Go.
So Roger says, OCR's investigation revealed a HIPAA compliance program that had been in disarray for a number of years. This hospital system's compliance program failed to detect and stop an employee who stole and sold thousands of patient records, lost patient files without notifying OCR as required by law, and failed to properly secure PHI that was leaked to the media.
Boom.
End quote.
So, a program that had been in disarray for a number of years.
Yeah.
That right there states it
Mm-hmm.
very clearly. And when I was originally, laying out how we're going to discuss this, I thought, well, we'll just do it as a discussion of how they calculate penalties. No, it is truly in disarray when you read all those things.
And it's always good to point out, too, because we hear, all the people freaking out about hacking and ransomware and all that. And it is a problem, but nothing in here was from an outside hacking incident or whatever. Everything is somebody did something they shouldn't have done or didn't do something they should have done.
All involved insiders.
Yep.
So the actual actions or lack thereof by Jackson Health System is why we're in this position. It has a lot of information in here. And if you go just to the document, which of course we're linking to the document as well as the press release, they had in their findings of fact, basically this is where they put the information about what the investigation found. And it includes 50 points. 50. A lot of those are legal ones, and but it's like this, then this, then this, then this. So first they have to identify that HIPAA actually applies, and then they have to do this and they have to do that. So they go through them all. Now, let's begin at the beginning. How did OCR even end up there looking through what was going on?
Okay.
Well, it's their first clue when the first item in the beginning, after we determined that they are a covered entity. On August 22nd, 2013, JHS submitted a breach notification report to OCR. The report indicated a loss of paper records for 1,471 patients from the Jackson Memorial Hospital's Health Information Management Department in January 2013.
All right. Way to go with that notification.
Yeah, spot on. And they called it, quote, the January 2013 loss. Okay, right away, when they're giving it a name, that means there's more than one. But August 22nd, 2013. Okay, that notification on the breach thing, that went into effect in 2009. That was supposed to be happening since 2009. Okay, maybe debate 2010. But by 2013, a large system like this one should have been closer to 60 days.
Yeah.
I'm just saying. And, we now know that employees, this was in the findings, told their supervisor about 2 different incidents of missing boxes of paper records from the emergency room in December 2012 and January 2013. So it was happening all around the same time. Apparently, the supervisor never mentioned it to anyone until there was an investigation. They never mentioned the December one to anyone. The January one finally happens. In March, they're doing an investigation, and they go, oh, by the way, it happened in December, too. I know. So, again, when we say people need to understand when anything like this happens, it's not for them to decide. It's for the people who understand HIPAA to decide, and just tell the employees, let me know. You should report everything. Let us to decide. Let us to decide. Yeah. So then there's the second one. And this one we know about because we talked about it.
Yeah, we did.
It was big in the news. OCR became aware of multiple media reports disclosing the PHI of a JHS hospital patient, a well-known NFL player. An ESPN reporter also shared a photograph of an electronic display board in a JHS operating room and a paper schedule containing the PHI of the same patient. Okay, we know who that one was.
Yep.
You're not going to say, you're not going to tell, you're going to lead me to that.
JPP.
JPP.
The funny part was like, everybody's like, oh, it's a HIPAA violation. ESPN reporter, he did a HIPAA violation.
No.
Because, remember we talked about it on that episode. We were like, no, the ESPN reporter can't, create a HIPAA violation.
Right. They have zero HIPAA obligations. Zero. And this happened, this goes back to the beginning of our podcast. Because it was July 2015. And we talked about it, like when it was there in the news. So this is like one of our earliest, like maybe even single digit number episodes. That's how long ago it was.
Wow.
And, because we started, end of May 2015. So the OCR sees the news. How about that? And, note to self, if you're in the news, be aware, they see it too. And they didn't get around to notifying them about the investigation until October 26th. And then, so it happens in July 2015. October 26th, they say, hey, we're going to investigate this because you were in the news. And then on February 25th, 2016. So again, we don't know if they notified the patient, but at least they were doing it by the year-end small breach notification deadline.
Well, I guess they figured the patient already been notified by the media.
So they did it in their year-end. You can do it at any time. So it's not like they couldn't have gone ahead and just gotten in front of this. No. They just tossed it in with any other little, we accidentally sent something to the wrong patient. A photograph was taken of an operating room electronic display board, which displayed the PHI of two individuals, including a well-known person in the community. That's what their report said in February. Then, you would think that's enough, but there's more. But wait, there's more. This is when it really became obvious. It already looked like nobody was paying attention, right?
Right.
It already kind of looked like that. So that you would think that at this point they would start doing something, but no, they didn't figure out that something was going on until another problem happened. And this is the third issue. And it was reported before the second one got reported because they waited till the end of the year. February 19th, 2016. And it makes me wonder if the second, one got reported on the 25th, only because this happened. But I'm not saying. They filed a report with OCR that an employee had been selling patient information since July 2011.
July 2011.
Yes. As part of that report, they said that 24,188 patients were inappropriately accessed by that employee over all of those years.
But we trust little Susie.
They've been here forever. They know HIPAA. Yeah. For 5 years, they've been stealing.
Right. I don't think my people would do that.
No. You can trust
Or-
them. They've been here forever.
Or they look at IT and go, well, why didn't you catch this?
Mm-hmm. Yeah. Yeah. Well, here's the really sad part is they didn't even find out about it, that they'd been stealing it for 5 years. It would have still been going on if an anonymous caller hadn't called the compliance department January 4th, 2016, and reported that an employee was selling patients EPHI.
Wow. So they didn't even
Who knows
find
how long it would have gone on had it not been for a whistleblower making an anonymous phone call.
Mm-hmm. Thank you, Snowden.
So they're not even paying. There's clearly gaping holes. There's not really any true privacy and security program going on.
Mm-mm. And nobody's looking. What's a cooking?
When you're not a looking, things are cooking. But I remember Jocelyn, what was her name? Samuels. She always said that, if there's a small problem, we have to look because that could be the indication of a canary in a mine. That was, I think, her or Devin McGraw when they were at OCR. And this is why, because they were already in there investigating, and that's when they started admitting to all this other stuff and finding this other stuff. But even then, they didn't find the big one. So, okay, we're reading through. Clearly, as the phrase, it's in disarray, that was not embellished.
Mm-hmm.
For years, not embellished. So, are we shocked to find out that the first place that OCR starts to check when they see all these things is, let me see your security risk analysis.
Mm-hmm.
And because we've got this going on for years, they want to see it for years. So just like we tell people, you need to keep it for 6 years. So each investigation, they could go back 6 years, each case. And technically, they were all different cases. So they said, show us your risk analysis and, show us what you got. Show us your cards. And of course, they always ask for the associated risk management plans.
Mm-hmm.
I was just reviewing a business associate due diligence, and when it said, do you do a security risk analysis? Yes, we did. Do you have a written risk management plan? We didn't have anything we needed to change. And I went, red flag. And then our next question on the questionnaire was, tell us the methodology you use. There's a lot of ways. We made a list of all the things we're required to do, and we made sure we were doing them. We're doing everything we're supposed to do. Okay. That is an indication of what's going wrong here, because that's not a security risk analysis.
Mm-mm.
I'm not saying, I'm just saying. I am saying, really, because how many times do we say that?
Yeah.
Over and over. And so they had 7, 14, 15, 16, 17. Yeah, 7 of them that were supplied. So 2009, 2012, 2013, they did internally on their own. Then they brought in a third party from 2014 to 2017 every year. They had paperwork. They were able to supply it.
Mm-hmm.
Then you actually go read the paperwork. And then they start making a list. There were 10 items from the beginning of talking about risk analysis to the end of talking about risk analysis and risk management plans. 10 items that were wrong with them. 10.
Yep. So they paid a third party for 4 years straight.
Well, and it was different. It clearly was different third parties. You can tell.
Yeah.
Yeah.
And they still had 10 items that were disarrayed.
Yeah. And in fact, they didn't really point out the serious problems in the ones they did internally. They pointed out the third party issues.
Mm-hmm.
Okay. So first of all, there's a serious problem when one of the first items they say is all of the ones prior to 2017, they use the term erroneously identified several HIPAA security requirements as not applicable to them.
Huh.
And I don't know how you could do that. That's the part, well, I guess that's also happens with, where the BAs say not applicable.
Mm-hmm.
But to flat out say that doesn't apply to us, we're going to skip it.
Yeah, you almost want to say, you know what? If you come up to something like that where you're saying it doesn't apply to you, then document how it doesn't apply to you.
Yeah.
How did you make that decision?
Yeah, they just marked it that way.
Right.
So, they made them fix that in 2017. So the very last one, also done by a third party, they said, okay, at least acknowledge these do apply to you. All right. So then they go through and they start talking about the individual issues. And it starts, and there's a pattern here. So remember, third parties did these. And it says third parties, not a third party.
Mm-hmm.
So it was more than one. And to me, it looks like maybe one did the first one, another one did the next two, and a third one did but who knows? The one in 2014 was deficient in scope of both the EPHI involved and the threats and vulnerabilities that exist in their systems. That's what it said. And even with that limitation, they didn't provide evidence or documentation of a response to the findings and recommendations of the third party. So no response. It's like, thanks, check mark.
Yep.
Here we go. We're doing check the box compliance. Same issue happens in 2015. Didn't identify all the PHI and didn't have all the threats and vulnerabilities, just like in 2014. But we're going to take this one a step further. Some sections of the SRA done by the third party were left blank. Just like blank. Nothing.
But that makes me ask, did anybody even look at the documentation this third party was even providing?
Again, check the box. Do we have the paperwork? Yeah, we do.
Yeah. Did anybody look at it? No. Just like we did.
It listed the same high-risk threats that were on 2014, and no one did anything about them either. So you'll never guess what happened on 2016.
Left blank again.
Yeah, it was clearly the same. That's why I say, the first one was one group. The next two were the same group because they still were deficient in scope and some sections were left blank. And again, same high-risk issues, nothing done. I feel as though I'm in an infinite loop.
Yeah.
Those of you who are developers know how painful that can be.
And just to point out too, OCR is not going back to these compliance companies and saying, "Oh, you're accountable."
No,
it's the covered entity that is accountable.
Yeah. So just because you had somebody do your security risk analysis, if it didn't include all the EPHI and it didn't include all the threats and vulnerabilities, and if you don't have a response of what it is you're planning to do in a project plan, then you didn't do it. You didn't do it. You did paperwork. You didn't do what you're supposed to do.
Mm-hmm.
So, although it doesn't appear that they cared because they had zero response to those, apparently they tried a different approach in 2017. Brought in a different third party, I would assume.
Okay.
But still, this one had a whole different array of problems. It didn't even include the whole system. A complete and thorough. So we haven't done it right so far. Let's narrow it down, which maybe if they had done a complete and thorough one and said, now we're going to apply this to the big, that would have worked. But they only focused on the main campus. Now, this is an absolutely huge health system. And it's very important to know. They are a nonprofit academic medical system. They operate 6 major hospitals, a network of urgent care centers, multiple primary care and specialty care centers, long-term care nursing facilities, and corrections health services clinics. So they treat over 650,000 patients a year, and they have over 12,000 employees.
Mm-hmm.
So you would expect when everybody will say, well, they're so big, they're doing it right.
Mm-hmm. No.
No, they're not.
Wrong.
They haven't done one correct yet. So the one in 2017, it only focused on the main campus, not the entire thing, and it was done compartmentalized by department.
Okay.
So they're having each department do their own SRA, which, there might be a way that you could. I mean, we break it down a lot of ways. Okay, anyway. So this one ended up being basically a policy review with staff interviews. And you and I know that plenty of people are like, you run a scan and you get a report and you ask if they have the policies and procedures and you talk to people.
Yep. That's what it sounds like.
We know people that's what they tell us is what a security risk analysis is. Okay.
Oh, trust me. I see that almost on a weekly basis in IT forums. Drives me nuts.
Yeah. I really do want to know who the third parties are, but they're never going to tell us.
Right.
And even if we found out, we couldn't tell anybody because we're just not those people. But boy, would we want to.
Mm-hmm.
So all you IT folks out there who are being told, all you have to do is fill in the blanks on some forms or some spreadsheets, ask a few questions and run your scans. That is what these are.
Yep. You are part of the problem.
Yeah. You have to do more and you have to identify all the PHI. When we say, did they evaluate your EHR? Well, no, they didn't look at the EHR. They don't even ask what EHR. They don't ask what your security settings are. They don't ask about, it's bigger than what most people think it is. And I mean, every single one of their security risk analysis was wrong. It was wrong. And they'd brought in third parties. What's interesting is they don't tell you any details about the ones prior to that, but I think it's because all of the ones prior to that were either done differently or they didn't want, who knows? My guess is they aren't much different. And because otherwise they would have given them credit for that. And I didn't see that in there anywhere.
Mm-hmm.
So we have an attitude that the security risk analysis is just paperwork. Don't we? That's what it seems like to me. Is paperwork and so on and so forth.
Yeah.
All right. Well, at this point, I've gotten through 30 of the 50 different things that were found. And then they just keep going on and on and on. It gets really bad at this point because now they get into the details of the employee that was stealing information. They did admit that the employee did not have the authorization or the authority to the level of access that they were using.
Okay, well, how'd they get in?
They were given it because nobody was paying attention. They had policies and procedures that said this individual shouldn't have that level of access. But no one even read the policies and procedures, apparently.
Okay.
Because no one was following it. The JPP case, they also found out that the nurse who released the information was still accessing the records even after there was no TPO involved, following the case. Apparently, there was also another employee that was doing the same thing that had no TPO reason for accessing JPP's records. And when I got to item 30 in the list, and it said, while all of these employees were sanctioned, their broad and excessive access evidences a lack of restriction, review, and or modification of the appropriate levels of access to EPHI.
I agree.
I mean, basically, you can get to anything you want. It's a free-for-all in a massive health system.
I'm just wondering if they corrected it.
We don't know.
Yeah, we don't.
There's no guarantees that they've corrected anything. And clearly, I mean, this place is a mess. And this goes back to 2017. You know how long it takes to turn these things around.
Mm-hmm.
Even with a moderately sized practice, a 6 or 7 doctor practice, if they haven't been doing what they're supposed to do, it usually takes 2 years. That's at least my experience.
Yep.
If a bigger one hasn't been doing it, whoa, you're at least 2 years is what we teach people. If you've been doing nothing and you're trying to recover and start doing things differently, there's change and all these other things. If you start a new organization and you build it in, it's different. You're building it as you build the organization. So I doubt there's dramatic change, but I hope there is, because this is about patient care and our faith in the healthcare system. We've talked about that.
Mm-hmm.
We say it every week. David says
it. Yeah, I do.
So they go through then after they make their huge list, and they hit the big points of here's all your violations. Because first they say these are all the things that happened. And then we say, here's all your violations. And they applied penalties based on their findings. And they determined basically 3 violations, 2 of them ongoing, and then 1 was the access to, not providing breach notifications. In fact, they admitted they had 0 breach notification policy until 2013.
Nice.
Yeah. So they did give them a break there and say, okay, because we had this start date of official 2013 was when the omnibus final rule said you absolutely have to be doing this.
Mm-hmm.
You really should have been doing it before, but you absolutely have to do it here. So, of course, that's when everybody started worrying about it. They didn't worry about it prior.
Right.
So they counted 31 days from the time it should have been done to the time they finally did it. And that was the one that they called willful neglect not corrected. Because it should have been done well before. They did ding them $1,000 each for all of the others, and they documented all these days. So they said that they had the problems with the ongoing lack of a security risk assessment or risk management program, a reasonable and appropriate access management controls. Those were the 2 big things with the reasonable cause culpability that they hit them with $1,000 each. But they counted 163 days in 2013,
mm-hmm.
and then the entire year of 2014, the entire year of 2015, and then 26 days in January 2016. So I'm not quite sure why they didn't push that further to 2017. Yeah. So they also noted in their computations that in this time frame from 2012 to 2018 that they had filed 150 small breach notifications that impacted another 391 people.
Wow.
And those are the ones that are reported. You got to assume that they didn't even know about plenty of them because they have no systems in place. If you got staff that doesn't bother to tell you about it for months, even if you're asking about it.
Yeah.
So, what? So, to me, this $2.1 million, how much was it? See, I don't even, the money thing, I don't know. Everybody calls it 2.15 or 2.1. Why don't we round up, call it 2.2? But basically, it's $2 million.
Mm-hmm.
And with a group this size,
that's nothing.
No. To me, it feels like, you told me I had to pay $200 and then I could keep doing whatever I wanted to do.
Yeah. It's kind of shocking because I really would have thought that this would have been a lot higher.
Yeah. And I think, well, they said that, it's a nonprofit and their job is to provide care to lower income, in communities with this and that. So, they tried to put all kinds of things in place to give them a break. And maybe they shouldn't have done that, but
yeah, I can see giving them a break when it's a settlement. I don't know. That's just me.
But see, all of those settlements start with this notice of proposed determination.
Mm-hmm.
And you get the notice of proposed determination that says, we found all these problems. And, imagine a small practice being told $2.15 million. So they go, can we talk about this?
Mm-hmm. Yeah.
And my bad. And I promise to do better if, you'll reduce the fee. And that's why we usually end up in settlements. But they announced this year they're not going to, treat it as the high-end fines for everything. And so it remains to be seen. Everybody makes these something. How many times do you hear, oh, you know that they know what they're doing. They're huge.
Oh, yeah. Yeah. I mean, they make excuses for all of it, right?
Yeah.
You know, my reply is always that it is highly unlikely they are doing what they need to be doing because they have such a massive and complex environment to deal with. It is much, much easier for a simple, small office to do these things than a large organization.
Absolutely. And then they'll tell you it's too hard for us to do. We're too small. It's too hard for us to do. And you know, it's too hard for us to do. We're too big. It's too hard for us to do. We're too small. I don't know who. It gets back to HIPAA made easy.
Maybe we should start the Goldilocks compliance program.
This one is just right. Well, I personally, all this did for me was to just reiterate what we know is going on, but it was almost shocking even to me. I have to say, it was almost shocking to see a complete disregard for the seriousness of any of this stuff, that they're not even paying attention to somebody stealing stuff for 5 years.
Yeah, I mean, the only saving grace they had is the fact that they at least did an incorrect SRA for a number of years. Because a lot of these small practices don't even have that.
Right. You ask them for it, and they're like, "Didn't somebody do that for us?" And then it's a scan of something. It's not even close to an SRA.
Yeah. Usually the ones I see, I'll say something about SRA and they'll say, I've got the policies and procedures.
Mm-hmm.
Well, okay, but where's the SRA? Yeah. Well, how did you skip to step 6? Where's that?
Or my IT company did it.
Yeah.
Okay, but where is it? Because you're responsible for it, not them.
Mm-hmm.
Again. But, it gets back to, is enforcement really making a dent in that attitude? I think, and I continue to say that the enforcement penalties and fines are the least of your worries. The big entities, they're going to write a check. They're just going to write a check. They may go on a corrective action plan depending on leadership. Memorial in Florida went on a corrective action plan. They took it seriously. These folks, they wrote a check and walked away. And, if they have another big event, which if they're not making things better, it's possible they'll have another big event and they won't go so easy on them. You know what I mean?
Another misconception we hear often is that, I have insurance to cover a breach. Yeah, you might, but it's not going to cover this.
Well, some of them would cover legal penalties and those kind of things, but not all of them. And the point is that there's, Poneman started watching now the long tail of these kind of situations, whether it's a privacy issue with a single patient or a huge data breach. And with this one insider, 22 million, really? 22 million, 22,000 patients were involved. So when we look at how much this enforcement, clearly this has been going on for years. You have to supply information, your people are involved, you're dealing with policies and procedures, you're trying to get ahead of things, you've got the legal fees, all of this kind of stuff. The big entities, they can absorb that.
Mm-hmm.
The smaller entities where everybody runs around talking about $1.5 million, 1.5. By the way, this reiterated that, after 2015, they're inflation adjusted. It's like 1.7 something now.
Yeah.
But everybody runs around talking about $1.5 million. It's really irrelevant to the vast majority. And when you look at the statistics, because I went and checked the numbers. So the total enforcement in 2019, 5 cases.
Wow.
For $5,349,000. And only this one was actual penalties. Everything else was settlement. And if you go back and you say since 2015, okay, so since we started the podcast, I said, okay, since 2015, 45 cases. And the average total is $1.85 million per case, whether it's a settlement or a civil money penalty.
Okay.
4 years, thousands of cases have been closed with just corrective action plans.
Mm-hmm.
That's it. Thousands. 45, thousands. Statistical likelihood of worrying about the 1.5 million, very low.
Yep.
Now, granted, the impact would be huge, but we're doing a risk analysis. What I should worry about is not that, but what it took to get there. And that as you always say, you do a risk analysis every time you talk to your wife.
I do.
It's the same kind of thing. I'm going to worry about the damage it's going to do to my business long before that damage is done, years before it gets to this point where anybody's even talking about 1 point something million.
Mm-hmm.
And the statistical likelihood of it being me, as long as we're not jerks or completely blowing it off, if you take it seriously and act appropriately, those penalties aren't your concern. What's your concern is what happens to your business and having to do these things. I mean, what's the difference if somebody's built up their security over years, they've spread the cost out.
Mm-hmm.
But if you have to come in and do everything in 6 months, how much does it cost?
Yeah. We're running into some of those when we pick up new clients, and it's like, we've got to replace nearly everything you have. And of course they freak out, and I'm like, well, we can still spread it out over time, but we need a plan to do this over, 3 years versus, 6 months.
Yeah. They act like it's the technology is a truck that I can drive for 20 years and haul my stuff around.
Yeah. It's fun. I had a person the other day said, well, I need to spend my money on things that generate revenue. And I said, well, try to run your business without technology and tell me how that works for you.
What'd they say?
They just stopped. Like I didn't hear anything for like 15 seconds.
There's a pause.
Yeah. And I'm like, yeah, just because that fancy laser machine makes you money doesn't mean that the other IT components in your business are worthless.
Oh, yeah. It's any company in the world today, or, most any. I'm sure that there's some that don't, but the vast majority use technology to make money flow.
Oh, yeah. Yeah. It's an indirect money generator because it makes everybody's jobs easier, faster, and all that. So it does make you money. It's just not a direct money maker.
Yeah. I don't see an immediate ROI, but I can't do the things that I do get the ROI on without this. So, if I don't have a foundation, I can't sell the house. Yep. I can build a house, but if I didn't put a foundation down, most people aren't going to pay the top dollar for it.
Yeah, true.
So anyway, I don't know what's the most important thing to learn from this. Is it that the penalties really may not matter? It's the years and years of dealing with the documentation and the questions and trying to recover quickly.
Mm-hmm.
Or, holy moly, people do not know how to do a security risk analysis, even those ones that are you're being paid to do it.
Yeah. And we have no idea what the brand damage is. We don't have any idea whether or not there's going to be lawsuits from individuals because of the breaches. I mean, so there still could be a lot more fallout.
And stuff we won't even know about.
Yep.
But the big health systems, you shouldn't compare yourself to them, but don't try to say, well, of course they can do it. No, they don't. They don't invest in it. they're not a good example because they might absorb all of that cost, and they have lawyers that are just sitting there waiting for work to do.
Mm-hmm.
You don't. So, and it applies to both of you.
Yeah. And it's still sad that people still look at everything HIPAA's asking you to do as being, just overbearing and out of line and all that. It is basic. And as we talked about last week, it's the floor of.
It is the bare minimum for protecting information.
Right. And whose information is it? It's the patient's information. That information does not belong to you. It belongs to the patients.
Yep.
So sad that it still has to be that way.
Yes. We want everybody to get on board and treat this as if it's not paperwork. It's not worrying about compliance. It's worrying about patient care. And that trickles all the way down to the IT people and everybody else.
Mm-hmm.
So there you go.
Good stuff. All right. So that is our show for today, folks. Remember to follow us and share us out on your favorite social media site. Hey, send us a review. We had somebody do one lately. Thank you very much.
I love that they said Dave's.
I know. Yeah. I wonder if they did that on purpose. But anyway. Yeah. Honestly, give us a review. We love reading those. We love knowing that people are getting a lot out of the show, but we also like hearing what you like about the show. So that
and with those, it helps us spread the word.
Oh, absolutely, because then we can use that to spread the word even further. So, so go take care of that. Do it now. All right. So remember, for Donna and myself, the HIPAA is not about compliance. It is about patient care.
You've been listening to the Help Me with HIPAA podcast, hosted by Donna Grindle and David Sims. The show created to help you with HIPAA. For more information or to ask us a question, visit our website at helpmewithhipaa.com. Neither Donna Grindle or David Sims are attorneys, and they do not offer binding legal advice concerning regulatory compliance. The information in this podcast should not be relied upon or construed as legal advice in any way. Consult your attorney for legal advice concerning compliance with HIPAA regulations.